Here in New Hampshire, we have a constitution that treats the public's right to know and free speech and free press with even more protection than the First Amendment of the federal Constitution. The founding fathers of this state indicated that these freedoms are so essential to the state that they must be inviolably preserved. There was a fellow named Jefferson, who I like to quote. He had been president for 2 terms when he made these statements, saying if he had to pick between a government or newspapers, he'd pick the newspapers. I think that's very telling. And also, if we limit the freedom of the press, we lose it. I love to cite this to government officials who I believe don't always have sufficient respect for the public's right to know. I have to remind them, I say, hey, you know, the Constitution says you're working for me. You're my agent, and you must be accountable to me. You must be open, accessible, accountable, and responsive. So, as I've said, I think any darn thing in the hands of a governmental official belongs to us. They're working for us. However, the statute 91A has exemptions from disclosure. So the law in this area is all about the exemptions. Some of them make a lot of sense. Personal school records of pupils, these are the first 3. Juries, grand juries, regular juries, parole and pardon boards, records are exempt from disclosure. This is the big one. Records pertaining to internal personnel practices, confidential, commercial, or financial information, which is very misleading. The way that statute's written, it looks like any financial information in the hands of a government official is not available for public inspection. That's just not what the legislature intended, and it's not what the Supreme Court has allowed to happen. It has to be confidential financial information before it can be withheld, and that's extremely limited. It's when there's, for example, a bidding process going on, and it would harm the government's ability to get the lowest bidder if bids were disclosed. Test questions, scoring keys, examination data, you know, common sense. But then we get to personnel, medical, welfare, library user, and other files whose disclosure would constitute invasion of privacy. There's those 2 trains crashing head-on. When would the release of information about an individual constitute an invasion of privacy? Here in New Hampshire, the Supreme Court has decided that if the disclosure of the information will shed light on the performance of a governmental agent or a governmental agency or actor, then an individual's privacy interest will take a back seat.